Hello, everyone. Firmidable is now live coast to coast. Welcome to successfully representing CDR and overpayment SSDI cases. Help your clients and your bottom line. I'm Nathan Chapman, president of Firmidable, a strategy-driven marketing and digital agency that works exclusively with law firms and especially Social Security disability firms. We were the first in the nation to bring professional marketing to Social Security disability, so we're the largest and most experienced in generating new cases in disability law. Before we get started today, just a couple of housekeeping items. If you have technical problems during the webcast, if you look at the bottom, you'll see a chat button. One of my team members is standing by to help you with any issues. He'll communicate with you privately to help you if you have any problems. At the end of the presentation, we're going to have a live question and answer period. You can submit your questions or comments anytime. If you look at the bottom, you see a different button, Q&A. That button to use, send anytime you want. As moderator, I'll decide whether to interrupt Jim with your question or save it until the Q&A at the end of the presentation. We've had a terrific series of webinars this fall. If you missed them live, you can watch recordings on Firmidable's website or email me, and I'd be happy to send you a link. This one in particular, about why most law firm digital marketing stinks, was actually the inspiration for today's program. We had a whole section about how to take leads and maximize the conversion of them into cases. Part of that presentation was talking about how to work with your intake team. You know how you might call and a company will say this call may be recorded for quality assurance. Well, in this part of the presentation, we talked about that quality assurance. So in doing this work with Social Security firms, I often noticed that they were turning away very quickly, left and right, overpayment and CDR cases. And that led to the inspiration that we should do a program like today. I'm really excited to have James Mitchell Brown, or Jim Brown as we call him, as our guest today. You know that old expression that if God didn't exist, we'd have to invent him? Well, I feel like if Jim Brown didn't exist, Nostra would have to invent him. I've been working with disability lawyers for over 30 years, and again, I go to Jim Brown and ask, what do you think about this? What should be the approach on that? Over and over again, I suggest to firms, you ought to go talk to Jim and work through that. Based in Cleveland, Jim's an attorney who consults with other attorneys around the United States on how to make their law practices more efficient, more profitable, and more importantly, more enjoyable. So to kick us off, we're going to let's survey the audience. We're going to do a little poll here, and let's see what you're doing now in terms of overpayment and CDR cases. Question should pop up for you shortly. Here it is. So select one. Do you currently accept CDR and or overpayment cases? You can either say, yes, we take both, only CDRs, only overpayments, or neither one. So let's let people have just a minute. We're not going to take long on this. And we will close it down, and here's my answers. Let's see, both 24% of the audience said yes, we actually do take both. 21% said we only take CDRs. Ooh, much smaller number, 3% only take overpayments, and more than half the audience, 53%, say they take neither one. So you've come to the right place. Today's program is for you. So without further ado, I'm excited to introduce to you Jim Brown. Jim, the floor is yours.
Thank you, Nathan. I've sat in on meetings of judges who are upset that lawyers don't take overpayments and CDRs. They said their cases the claimants could win, but they need a representative and they can't get one. So you create some goodwill with the judges also if you take these cases. If you do it, one of your responsibilities is keeping your clients out of the homeless shelters and the hunger centers. It's, by the way, great to go volunteer at them, but that's for another time. If your clients are given a huge overpayment or have their disability stopped, this is where they're going to end up. You've kept them out of there for a while now. Keep doing it. One of the important things in my practice is protecting my clients from suffering a CDR. I use a letter when I win, and I'm going to share that with you. It keeps them from being terminated, and the side benefit is it improves my expense reimbursement. I say, congratulations, I received a copy of the notice of award. I'm pleased I was able to obtain all the evidence needed. Take credit. You did the work. Tell them you did it. Social Security found your disability began. This particular client, it was July of 22. Benefits began in November of 22, and Medicare begins in November of 24. Call me when you receive Medicare information. If you do anything with Medicare insurance, you want to make sure you put that in so that they don't go picking somebody they see on TV. They're going to call you. Next thing I do is dollarize what I did. This was a younger person. If he remains disabled through retirement age, he's going to get about $450,000. I figure out his monthly benefit. I make a rough guesstimate of the cost of living increases each year. I don't spend a long time figuring it out. Because he's getting disability, his retirement's going to be about $115,000 higher than if he had all those years of no earnings. So take credit. Your fee looks minuscule compared to how much they're getting, but they appreciate that. The next thing I do is put a little fear into them. Social Security conducts a review every 3 years. I say until age 65 here. They're supposed to stop at age 59, but I've had a few people reviewed in their 60s. So let them think about that. Call when you receive the notice. If Social Security finds you're no longer disabled, it's a lengthy process and benefits may not be paid. And then I tell them, thank you for trusting me with your case. If you need an attorney for anything else, give me a call. I recently had somebody call me who had a great malpractice case that I referred out. And at some point in the future, I'll get a nice referral fee. And then I say, if your family or friends need to discuss any legal issues, I'd be pleased to speak with them. Remind them to have people call you. You want them referring their family and friends to you when they need you. And the last sentence is, I've enclosed a statement for expenses incurred. Your clients aren't educated, but they're not dumb. And they totally understand that you're not going to help them when they get reviewed if they don't pay you. That letter helps increase payment of your expenses tremendously. And then the next page is the list of expenses. My payment rate is close to 100%. I rarely have somebody not pay me. And then I enclose a notebook. Notebook has a pen with it. And it says to write down the date of each doctor appointment and the name of the doctor. The date and the name of new medicine every time they get a new medicine. And when they have a bad day, write the date and a brief description of the bad day. When they fill the notebook, call me and I'll send them a new one. When they get their review letter, I tell them to fill out the form and then take it to the field office along with the notebook and tell them to copy the notebook. The people in Ohio who have to do CDRs are supposed to do 31 a week. If you give them 50 or 100 handwritten pages in addition to the form, they don't look at it. They just say, this person's still disabled, and they go on to the next one. You don't really want your clients to need you on a CDR, but you want them to have something, excuse me, with your name and your phone number so they can tell their friends to call you. But when it's somebody who's calling you out of the blue, it's a new CDR case, you have to get some information. Are they getting medical care? If they're not getting medical care, in almost every situation, you can't help them. You have to prove that their condition is the same or worse than it was when they got disability. Have they worked? Have they made over SGA? I have somebody call me every month and they've worked right up to the SGA limit. And when I say, why didn't you make more? They said, because I didn't want to lose my disability. That's waving a red flag in the face of Social Security. You're saying I could be working more, but I'm choosing not to. I tell my clients not to make over $1,200 a month and to write a description of each day they work. But you don't want them, the people who are close to the limit and aren't going over, you're not going to help them much on the CDR if their condition the same or worse. Social Security has to prove that they've improved enough to return to SGA. If Social Security can't prove that, you win the case. You need their physician to say their condition's no better than it was when they got their disability, with the caveat that some conditions don't require medical care. My classic one was in 1982. I had a client with cerebral palsy. He couldn't lift his head off his chest, but he didn't get medical care because there was nothing anybody could do for him. Social Security cut him off because he wasn't getting medical care, and he called me to appeal. It was at the same time CBS was looking for somebody from the Midwest with a chronic disease who was being cut off of disability, whose spouse was in danger of losing their job, who was going to lose their house, car, or both. I gave them this name, and I was on a CBS special with Bill Moyer about people falling through the Reagan safety nets. The show aired on a Wednesday, and on Friday, his check was hand-delivered to him. If the person's answers are okay as far as getting medical care, condition being worse, then you're going to charge a retainer. My retainer is usually 20% of each month's benefit. I explain why I'm charging this retainer. I get their debit card information, and I get the date that their money is deposited into their account. The day it's deposited is the day I run the card and take that 20%, which goes into my trust account. My retainer says I'm retaining James Brown to represent me in the claim regarding a CDR. I'm allowing him to take a certain amount of money each month for my disability benefit. If he successfully gets to let me keep my entire, if he successfully wins, he gets to keep the money that I paid him. I agree to provide him with a debit card number and permission to withdraw that sum each month from my account. And they initial it. That's important as far as the bank's letting, as far as the bank's letting you have permission to take the money from the account. I agree that if this SSA favorably decides my claim through the initial hearing, my fee will be the sum of the money that I've deposited each month, but must be approved by the administration. A fee petition may be required. I don't want to say that the judges aren't always paying attention, but half of the time I get a decision that says the attorney's fee authorization is approved without requiring a fee petition, and I take that to mean the money in my trust account is okay as my fee. I then make them initial that they understand there's no past due benefits, which is why the monthly fee is being charged. Again, that's not your fee. It goes in your trust account until you get a fee authorization. I also tell them they're responsible for expenses. I take the right to withdraw because you need a right to withdraw if it's a problem with the client, if it's a problem with the case, for any reason at all, you need that right. And I want the right to settle the case if for some reason I can't contact the client. The next thing that's fun and enjoyable and rewarding are representing people on overpayments. Most lawyers run from the word overpayment. They can be very profitable. You have to look at it properly to turn this into a valuable part of your practice. The first rule is if you can't get paid, don't take the claim. Now, there are some people I talk to that I won't take the claim because I know they can't pay me. Recently, somebody called me who was overpaid about $40,000 in SSI. And what happened is he applied in 2020. By some computer glitch, they gave him past due benefits going back to 2017. This year, they told him they paid him 3 years too much, and it was their fault. Well, they didn't say it was their fault. They just said, we paid you 3 years too much, pay us back. He's getting SSI. He couldn't pay me a retainer. But I gave him a letter that he should give to Social Security. It said, it wasn't my fault. You made a mistake and overpaid me. And the only income I have is SSI, so it's a hardship to pay you back. They waived the overpayment for him. I didn't take the case. He couldn't pay me. It wasn't going to require much anyways, but I helped him because that's who I am. You'll get some calls like that they don't need you. On the other hand, I had a dentist call me who was on disability, and he was working 1 day a month. Sometimes the company he was working for paid him twice in 1 month and not at all another month. When you looked at his earnings, it looked like he had over 20 months of earning more than SGA. If you unpeeled it, you saw that he didn't because some of those earnings were for different months. He refused to pay a retainer. He said that I should do it because I'm a disability lawyer and I should help him because he's disabled. When I asked him if he ever did dentistry for somebody who couldn't pay, he said, no, he's a professional. I wouldn't help him. He had his hearing and lost on the overpayment and owes about $100,000. If you don't think you can win, don't take the claim. It doesn't take long to look at the papers on an overpayment, although often they don't provide you all of their papers. Sometimes you have to have the claimant go to the Social Security office and get their whole file pertaining to the overpayment. When you get it, sometimes it's blatant why they're wrong. Sometimes it takes you 10 to 20 minutes to figure it out. But if you don't think you can win, don't take the claim. If you do think you can win, you can run with it. If you can't help your client, they have nothing. Their pockets are empty. So they need your help, and it's up to you to step up and do it. I had a claimant who was allegedly overpaid $150,000 in SSI benefits. His representative payee, who was totally unrelated to him, called me to see if I could help. It turns out he was the beneficiary of a trust that he could get money from anytime he wanted, except he didn't know that the trust existed. His grandparents created the trust, which was funded after they died. His uncle was the trustee. His uncle never told them that this trust existed. So this man who was in his early 40s was getting SSI, and they said he was overpaid over $150,000 with the standard language, please send us a check for this amount in 30 days. I used an estate planning lawyer to write me an expert witness letter. And he wrote the letter explaining how in probate law, if there's a trust and you don't know it exists, so therefore you can't access it, it's the same as if it doesn't exist. He had no access. He didn't know it was there. So therefore, it was as if it wasn't there at all. The money was, while all this was going on, the money was put into a special needs trust to protect it from Medicaid. In any event, the Social Security Administration was thoroughly confused by the letter from the estate planning lawyer, but they waived the overpayment. Because the person who was his representative payee and not a relative retained me, the claimant signed the 1696 The representative signed the engagement letter, so I didn't have to file a fee petition on it. I have another one I'm waiting for a decision on it now. This young lady was overpaid $142,000, and her benefits were terminated because she was working. She has muscular dystrophy. She can't sit up. She slides down. She needs somebody to sit her up. She was working. Her gross earnings were over SGA. She paid her taxes. She paid into Social Security, and they hit her with this overpayment and cut her off. What she didn't know is she had a full-time aide, and she was entitled to deduct the cost of that aide. She filed 6 years of amended tax returns, got refunds on all of those. And when she went to work, the aide had to go with her and keep propping her up, sometimes had to hold her up. The aide had to take her to the bathroom because she couldn't go by herself. The company had to build a special bathroom that the aide could be in with her. She's now completely bedridden in a nursing home, catheterized 24 hours a day. So getting benefits reinstated wasn't going to be the difficult part. But I explained to the judge that this wasn't a fault problem, a hardship problem. There was no overpayment. The judge was trying to figure out how he could make a decision on this. And he said, maybe it's against good conscience. And I kept saying, there's no overpayment. With her amended tax return, she didn't earn over SGA. So you just have to find that there's no overpayment. The judge is probably going to come up with some convoluted reason why she doesn't owe the money, and will accept it. But it's one where you use your creative cap and you find a reason why you can win the case. This is one he's overpaid $235,000. At first blush, I thought it was hopeless. The person is earning over $200,000 a year. He's back to work. He has some severe OCD problems. He got Social Security disability in the early 2000s, went back to work, claims he made a phone call to Social Security, but there's no proof, and they found him overpaid. He repaid them, then went back on disability for several years. When he went back to work, he has 9 different letters that he's given to Social Security, and he actually took them there, has stamped copies of each letter he gave Social Security saying, I'm working, here's how much I'm making, stop my Social Security. They didn't stop it, and he spent the money. He's without fault. Clearly, he told them, and they kept paying him. Now, income of over $200,000 a year, where do I get the hardship? Well, it took a while of probing with this claimant to find out he has over $500,000 in debt. He went deep in debt when he wasn't working, and he's paying off these debts. That's $500,000 in debt, not counting the Social Security. So I've got the hardship part too. I still have to convince the Social Security judge of that, but I think I can do that. I got my retainer from him, half non-refundable, because the lawyer who referred him to me is the one who signed the engagement letter and took the engagement fee. And that lawyer engaged me to represent this claimant. In my engagement letter that a third party signs, it says, thank you for choosing me to represent you on the overpayment. Tells you what I do on the cases. It says, for an overpayment, I charge a flat fee of blank, remit it by check or credit card as soon as possible in order for me to file the appeal. The amount I'm charging is less than the 25% of the overpayment that I usually charge. My fee is usually 12.5% to 15% of the overpayment, sometimes 20%. 50% of it is non-refundable, and 50% of it will be returned if I don't get a decision that at least equals the amount of the retainer. This next part is part that Ohio requires me to put in any engagement letter about the interest I charge if they miss payments. It's not usually relevant in these cases. Thank you for agreeing for retaining me to represent you. Contact me when you have questions. Sign and date the letter and return it to me with the retainer. And it gives them a chance to pay by credit card or by check. If they pay by credit card, I add 1.5%. My credit card company charges me 2.25%. So I pay a little bit of it, but they have to pay part of it. If it's an overpayment retainer, meaning that there's no third party paying me, I again have the client sign in several places. I'm very clear about the terms, and I make sure they understand there's no guarantees. Some people think, well, if I'm representing them, I'm guaranteeing I'm going to win. I want it to be very clear that there's no guarantees, and I tell them that up front. I tell them before I represent them, I'm going to look at it, and if I don't think I can win, I won't help you. But no guarantees, and you have to really emphasize that. And here's the retainer. I'm retaining James Brown to represent me regarding an overpayment of X amount. I pay retainer of blank to my attorney, and then they initial that. 50% non-refundable, the other 50% payable only if the overpayment is reduced by at least the amount of the retainer. Again, because I have to file a fee petition on this case usually, the 50% may have to be refunded. A fee petition may be required. It may be approved without the filing of fee petition. Again, half of the time, the judges just put the standard fee authorization page on there, and I don't file a fee petition then. And I emphasize no guarantees being made. I may charge expenses on this person with the $235,000 overpayment. I paid for a great letter from his psychiatrist explaining why he wasn't competent to do some of the things that should have been done during the period he was on disability. And giving me the right to settle the case if I have to. I have somebody now who I won disability for a closed period that ended early last year, but the award letter came out, and the award letter came out recently, and it's still paying her. And I told her, put that extra money in a bank account. She's saving it. And at the time that they find the overpayment, I already wrote Social Security and said, you're paying her the wrong amount. This was a closed period. So we've covered that base on that. At the time that they find she's overpaid $25,000, $30,000, $40,000, whatever it is, she's going to have the money, but I will settle the amount. She overpays them $50,000 and I offer $25,000, they'll probably take it, and I'll charge her 20% of the savings. Without fault is crucial. Did they notify Social Security regarding workers' comp they're receiving? If they put it on the claim when they filed, that's good enough. Did they notify Social Security they went to work? There's one argument that hasn't been tested thoroughly yet, that if you're working and Social Security is being deducted from your paycheck, you're notifying Social Security. It's a good argument. Is it going to carry weight? It should, but I don't know if it will. Sometimes you have mental problems. And sometimes Social Security just calculated incorrectly. So you have to look at all of those things. One of my favorite overpayments was somebody who was overpaid in the neighborhood of $60,000, and her two disabled children were also overpaid. And what happened is she signed up for disability in 2001. They said that because of her DLI, she could only get SSI. Her two sons were disabled, so they also got SSI. Her husband said he moved out of the house, but he bought them a house to live in. He gave Social Security an affidavit in 2006 saying that he wasn't living in the house, but they had videos of him living in the house. So they indicted both of them. They said they were overpaid, and that's when she came to me. Her DLI was 2000. When she signed up in 2001, Social Security was having some terrible employee problems. And they never said to her, when did you last work? Oh, maybe you should sign up for disability with a DLI of last year. So I got the original application open based on Social Security's mistake. They ended up paying her disability, not SSI. And with the increased benefit, that wiped out the overpayment, wiped out the kids' overpayment because of their children's benefit they were entitled to. They dropped the criminal charges against her. They wouldn't drop them against her husband because he lied on an affidavit to Social Security saying he wasn't living in the house when he was. And they refused to drop it against him. But at least the overpayment was done. Most of the criminal charges were done. He pled to a misdemeanor and lost his job at the VA as a respiratory therapist, which he got another job like that at a hospital pretty fast. But you have to look deeply into these things. There's sometimes some really creative ways you can get to the right solution for your client. You can get an overpayment waived if it defeats the purpose of the act. If somebody's getting SSI, it's easier to prove that. If they have TANF funds, formerly ADC, it defeats the purpose to say they're overpaid. If they have non-service connected VA benefits, which are based on need, it defeats the purpose. If they're getting food stamps, it defeats the purpose of the act to say they have to pay an overpayment. And if Social Security is subsidizing their Medicare benefits, it defeats the purpose of the act to have them pay an overpayment. It also defeats the purpose if the household income is below 150% of poverty level, if the payback tolerance has now increased from $55 to $250. So if a person's getting $1,200 a month and they have $1,000 a month in expenses, they don't have to pay back $200 a month. They're allowed up to $250 in extra money. If there are resources on hand, and you can exclude from resources on hand home and property, furnishings, 2 vehicles, sometimes 3, and $6,000 in liquid assets, $10,000 for a couple. If Social Security is the only income, it's easy to prove it's a hardship. If they're also getting workers' comp, it's a little tougher to prove because that's added income. An air traffic controller on workers' comp is getting $100,000 a year in temporary total disability. If they're getting $100,000 a year plus Social Security, you have to be creative to show why it's a hardship to pay it back. But dig into the basement of your mind, come up with the reasons why it's creative. If you want more reasons, at the NASCAR meeting, I'm giving a talk on using creativity in representing claimants, in managing your practice, and in marketing yourself. But creativity is the secret to your success, and it's the secret to winning these overpayments. The person with $100,000 a year in workers' comp plus Social Security may have a huge mortgage payment, car payments, medical bills, college tuition for their kids. You can come up with a lot of expenses to show why that overpayment is a hardship. If it's against good conscience, they don't have to pay the overpayment. What does good conscience mean? And how do you prove it? That's the great unknown. You have to touch the heart and the mind of the person making the decision just to let them know this is totally unfair. There's no definition, but if you push the right buttons, you can get that. When you became an attorney representing people on disability claims, you did it to help people. You especially need to help your former clients. It drives me nuts to have the people who will call me about an overpayment or CDR and say they called the attorney who represented them and was told they don't help on that kind of case. These were your clients. You helped them. Did you tell them about notifying Social Security if they work? Did you tell them about notifying Social Security about their workers' comp? Did you tell them what to do to make sure they didn't suffer from a continuing disability review? You have a lot of obligations when the case is over, but you can make the life easier for your clients. While you're doing it, you can earn decent fees and you can enjoy your practice, because that's what you should be doing. You get into a rut of handling the same kind of cases in the same way. If you take that overpayment, you take that CDR, you're a little out of your regular channel of doing things, but it can be a lot of fun. You take on the new challenges, you enjoy them, you work on them, and those new challenges really let you enjoy your practice and enjoy your life. Do we have any questions?
All right, Jim, thank you very much. I think that was really helpful and a message a lot of people need to hear. I do have a couple of questions here. If you have any more that you want to submit, go ahead and be doing that while we're doing this first couple of questions. The first one is, what happens if the overpayment amount is clearly wrong, but they can't afford to pay an attorney?
That's depending on the situation. Sometimes I will just give them a letter. I'll write 2 paragraphs and say, here's what you tell Social Security. I won't put that on my letterhead. I'll give it to them on some plain paper or on an email and say, tell Social Security it's wrong because they calculated this incorrectly or they did this wrong. And I won't represent them. I won't put a lot of time into it. If I know what's wrong, and it's like that dentist I commented on earlier, the overpayment was clearly wrong. He could have paid me and he refused. I had a lady who had a huge overpayment. She'd been married 6 times. Each time one of her husband died, she called Social Security to see if she would get a higher benefit from the newly deceased husband than the one she was getting benefits from. And each time they paid her benefits on the newly deceased husband without taking away the old one. So she was getting benefits from 6 deceased husbands. And her overpayment was huge. It was going to a hearing. And it was going to a hearing with a judge who used to be an OGC attorney. He had applied 2 times previously to be an ALJ. To be an ALJ, you take the civil service test, you get interviewed by a current judge, somebody from the federal personnel office, and somebody from the private bar. I was the attorney from the private bar who interviewed ALJ candidates for any agency in Ohio. If they don't get 15 points on the interview, they're off the list. This OGC attorney flunked the interview twice. And he was really a nice guy. So I helped him with the interview. And we spent 2 hours prepping for the interview. He passed it, became a judge. He's one of the most liberal judges in Texas, and that's who her hearing was going to be. So I knew I could win it. She didn't want to pay me an overpayment, or she didn't want to pay me a retainer. And she was upset when I told her that she would be back to getting benefits only from one of the former husbands, not from all of them. So I wouldn't represent her. She lost before that judge and kept that huge overpayment and has her benefits cut in half. Now they wouldn't do that. They'd only take away 10%. But if the people don't want to pay a retainer and you know you can help them, send them away.
Okay. Here's a different question. On a CDR, should an employer's accommodations be considered in determining whether the claimant can perform SGA?
Absolutely. Depending on what those accommodations are, those can be very important. I had one recently, and it was a judge that knew me pretty well. And the doctor called me up and said she didn't like the medical source statement I sent her. She was going to do her own. And I said, well, I've created that and it does well with Social Security. She said, it's not good enough. I'm sending you mine. Yeah. Her medical source statement was 23 pages long, including 21 accommodations. The judge on his hypothetical, his first two got some jobs and then no jobs on the next three. So I started asking hypotheticals with the accommodations. And I gave one and the vocational expert found a job. When I gave two, there were no jobs. The first and the third, no jobs. And the judge said to me, how many hypotheticals do you plan on asking? And I said, with all of these accommodations, I'm going to have between 300 and 400 hypotheticals, depending on the answer. The look on that judge's face was priceless. And he said, I'm willing to agree that there will be no jobs with two or more accommodations necessary. Accommodations are important. If you have to look at it, one of the accommodations I had a client had was they needed a close-in parking space. That's not going to be an essential accommodation to prohibit employment. But accommodations are crucial to whether or not they can do it. But you have to get something from the employer as well as what the claimant's going to testify to. And you need the claimant to say, I couldn't do the work without those accommodations.
Okay, that makes sense. Can you explain the role of subsidies in an OP case? How does an attorney go about chipping away at the earnings using subsidies?
Can you clarify that question a little bit? Whoever sent it in.
Okay, tell you what, we will come back to that.
Yeah, what kind of subsidies do you mean is what I want to know.
Okay. A different one. I often see an overpayment case, but Social Security has agreed to accept only $20 a month from ongoing benefits. I just tell them to pay the $20 and don't worry about spending money to fight the OP, which is likely not defensible. I consider that the best result. Do you agree?
I agree, but I give them a choice. If they, depending on the size of the overpayment, if they want to fight it, they should know they can, but what it will cost them compared to paying the $20 a month.
Okay. How is the 50% retainer non-refundable? What if a lower fee is approved? Must the non-refundable portion remain in the escrow account until the fee is approved? What if an overpayment is approved without a hearing? How does the fee get approved? There are several questions in there. I could go back through them.
I can peel them apart.
Okay.
If it's a third party retaining me, then I don't have to file a fee petition. So the workers' comp lawyer gets the retainer agreement of $15,000. They then pay me $15,000 to represent John Smith on this overpayment. John Smith signs the 1696, but Smith and Smith, Jones and Jones, retain me. It's a third party paying me. So 7,500 is non-refundable and is mine because that's my agreement. 7,500 goes into the trust account and is only mine if I win the case. I don't need to file a fee petition because it's a third party paying me. If the person hires me directly, I'm going to need some kind of approval. I can say it's non-refundable, but I don't spend that money. I may have to give it back if I don't get some kind of approval. The only thing that happens is if I go to hearings, half the time the judges don't even ask for a fee petition. They just say your fee agreement is approved. And they're not paying attention to I'm supposed to file a fee petition. So if they say my fee agreement is approved, which is the retainer I filed, I think that's good enough.
Okay. Here's that earlier question where he's now elaborated about subsidies. I briefly hired a non-attorney to assist with OPs as they had experience working for a nonprofit. This non-attorney rep was paid by the nonprofit irrespective of the outcome. The person had mentioned to me that subsidies were used to lower the gross earnings to get them below SGA and evade the OP. Does that tell you enough?
Okay, yeah. I got involved in one like that, where a church hired somebody who was on disability. And every year they gave him a raise equal to the cost of living Social Security gave him, but always kept him about $200 a month below SGA. But they wanted to do more for him. So they started giving him a $100 a month grocery store gift card. And then because he couldn't drive, they paid for his Uber to take him back and forth to work. And they were giving a variety of other subsidies like that. It was an interesting case. And we were able to show that the church paid for health insurance for their employees, and this person didn't need health insurance. They paid for a pension plan for their employees, and he didn't have a pension plan, all of which would not have been included in SGA. So they were just compensating him comparably to the other employees, and it wasn't really income. We had one of the kinder judges, and based on that, the judge agreed that it wasn't really income and waived the overpayment. You have to be a little bit lucky, a little bit creative, and have the right set of facts.
Okay. I'm going to end on this one. Any tips on how to tell someone empathetically that you can't help them? It breaks my heart sometimes.
I had one of those last week. And this was a young lady with MS and terrible tremors. And she works at Starbucks. And she was working 12 hours a week. And then they changed the rule that she needed to work 15. And then they changed it. She needed that the minimum amount you could work was 20. So her hours kept going until she was above SGA. And she didn't want to give up her job. She liked that. And I told her, you're making too much money. You're not willing to stop making money. You're not willing to admit the accommodations that they give you to do this job. And there's nothing I can do for you, but you're going to need disability again in the future. Call me when that happens. But there was just nothing I could do for her. There are people who clearly are disabled and they get fed up with the medical system. Doctors aren't often the nicest people in the world. and especially if you have a chronic condition. So they quit going to the doctor, and then they get their CDR and they have no medical care. Without a doubt, they're disabled, but you can't prove it. You can't help them. It's why in my closing letter to my clients, I remind them that they have to keep going to the doctor. I think that's one of my obligations. It bothers me that a lot of people don't tell their clients that. They don't prepare them for the CDR. And the person who is clearly disabled and getting no medical care has nothing you can do to help them unless they have one of those chronic, non-treatable conditions. Back during the Reagan years, when they were cutting off 500,000 people a year, somebody came to me who got a letter saying, give us proof you're still disabled. She didn't understand the letter. She got another letter. Then she got one saying you have 30 days. And then she got one saying, you didn't give us any proof you're still disabled. So you're apparently no longer mentally retarded and we're terminating your benefits. I called the person at DDS and I gave them the Social Security number and said, find this file and tell me how you cured her. He thanked me and reinstated her benefits immediately. And I got along great with DDS ever since, because I could have really given them some bad publicity. So there are some people who don't need medical care. Most of them, you need it. And if they're not getting it, you just have to tell them, I can't help you.
Okay. All right, we're going to leave it there. There were a couple of more questions coming in. I'll get those to Jim directly. It's all the time we have today. But any other questions that either today or you think of later, I know Jim or I would be happy to help you. So just reach out to us directly. Once you leave today's webcast, you're going to receive a survey on the presentation. We'd appreciate if you provide feedback so we can create, further programs that you'd enjoy seeing. You'll also receive a follow-up email with a link to a recording of today's webinar so you can share it with other members of your team. On behalf of the entire team here at Firmidable, as well as consultant Jim Brown, thank you for joining us today. Now go out there and get some great clients.
Thank you.